We will call the matter of the Stowe and Robinson children. This is the date and time set for a pretrial. If I could have counsel put their names on the record, please, starting with Mr. Sommerfeld.
Thank you, Judge. Don Sommerfeld, representing the Department of Health and Human Services.
Mr.
Larry
Delaney.
Brown on behalf of the children.
David Delaney, counsel for Jeremy Stowe, who is present via Zoom.
All right, I do see Mr. Stowe is with us. I also see both of the mothers, Robin Robinson and Paige Warner, are with us. Ms. Constant was with us from the SSU Tribe. Thank you for being here today. Appreciate that. And then we have Ms. Cerveny with us also from MDHHS. So I believe that we have all of the parties present and accountable for. When we were here last, we had a contested preliminary hearing. I did find probable cause to authorize the petition, and we set today's date as a pretrial. Mr. Delaney, as attorney for Dad, have you had an adequate opportunity to speak with your client about whether or not we are going to be proceeding to trial?
I have, and let me make a statement and then see if he wants to meet with me. The premise of the abuse neglect case is a criminal matter, which has not been adjudicated yet. I'm not counsel in that matter. So I believe that this case, the civil case involving the children, would proceed to a jury trial, and he would not enter a plea in this case at this time. If that's changed, my client would need to let me know, since I'm not involved in his criminal case. But that would be also a jury demand.
Is that accurate, Mr. Stowe?
So far as of now,
All right.
I'm taking nothing.
All right. One other consideration, Mr. Delaney, would be as to whether or not you want me to consider adjourning the matter for the disposition or for determination of what happens in the criminal case first. And I'd obviously want to hear from Mr. Sommerfeld on that idea or not. But I have known cases where that has occurred in the past. So have you given that any thought?
Meaning that let the criminal case be adjudicated first, then this case?
That's what, yes.
I would like to proceed that way. I think it resolves a lot of issues. The department has not supported that view before. It certainly clears the path depending on what happens in the criminal case.
And that's why I wanted to hear from Mr. Sommerfeld before I make a decision on that, but I did want to raise the issue. So Mr. Sommerfeld, your thoughts on whether or not we should adjourn this matter pending the criminal case determination?
Judge, if you look at the rules, one, the department would not stipulate to that. The whole premise of a neglect and abuse case is to provide permanence. That's either reunification with the parents or in some other form. We're seeking termination of parental rights here. Criminal trials can go on for years, and that really puts our opportunity here for the question of is Mr. Stowe unfit because of allegations made by his daughter? And, the passage of time is not fair to the department. Things can happen. People don't remember things. People change their minds. There's a lot that can go on there. But, in order to keep the spirit of this case, we have to proceed. I have not worked in a county that does waits for the jury trial to conclude. I've never been involved in a situation like that. This would be a first for me. And I mean, Mr. Stowe, he could request a trial, or there could be motions in his criminal case. I don't know the status of where he's at right now, what he's considering. So all of that unknown goes against, we have a removal order here. And if the child is in placement, the trial must commence as soon as possible, but not later than 63 days after the child is removed from the home unless the trial is postponed by a stipulation because process cannot be completed or because the court finds that the testimony of a presently unavailable witness is needed. This is 3.972. This is the court rule, Michigan court rule, A, 1, 2, and 3. And none of that says, there's not a number 4 there that says, well, if there's a corollary criminal matter, that takes precedent just because there's an opportunity for him to lose his freedom. It doesn't say anything like that. So the department would object to that approach.
All right. I think what I'm going to do then in this circumstance is I'm going to schedule the matter for future dates here in this case, move it along as it normally would. If there are any specific instances where Mr. Delaney thinks that there needs to be a delay because of the criminal case or some function in the criminal case, I would certainly allow him to raise the matter, and I would reconsider that in the future as things move along. If there is going to be a long delay, I would agree more with Mr. Sommerfeld. If there's going to be a short resolution of the criminal case and there would be due process issues in one or the other proceeding, I may be swayed one way or the other. But I simply wanted to raise it now and see what the thought process was. So we'll move along for that. Mr. Delaney, from your perspective in this particular case, how long do you need to be prepared for trial?
Let me ask the department how long they think a civil trial would be. If they're asking for 2 days, then I'm going to need 60 days, 90 days to get ready. So I haven't seen their witness list or exhibit list. So if I could get that information, I could answer the question. And then I'm always happy to involve Mr. Brown if he has a position on the criminal versus civil. If he doesn't, that's fine. But I know he handles those areas also and has a fair amount of expertise.
Your Honor, I don't think I would take a particular position on this. The children are both with their non-respondent mothers. I don't have any issue with their current placement. I would leave that up to the other attorneys, you know, again, as Your Honor stated, depending upon how long this criminal case may take, that might be a matter that needs to be argued at a future date.
All right, Mr. Sommerfeld, how long do you need to be prepared for trial?
Judge, I would be willing to stipulate to go outside of the timeframes. I know that I'm not going against my original argument. What I was saying before is that there could be considerable delay in the criminal case, which we're talking about, like, you know, a year or something like that. I would think 90 days. I did speak with Ms. Cerveny about potential witnesses. We may be able to get this done in 1 day. I may only have a couple witnesses and one certified copy to present. But essentially, we would be presenting the daughter and Ms. Cerveny, and that's where we stand right now. And then there would be a certified copy that Mr. Stowe is criminally charged with criminal sexual conduct against his daughter in a different county other than Otsego.
All right, so it looks like it's a 1-day jury trial at now. We can set it for 90 days. If there's any changes in stance, we'll have a status conference probably 10 days in advance of that to check those things out.
Judge, I would like the parties to agree if we're going to go out to 90 days, that is beyond the timelines, and we can, upon stipulation for good cause, if we all agree, that would be acceptable. Otherwise, we have to set the trial sooner.
All right, Mr. Delaney, is that sufficient for your needs, and is that with your consent?
Yes, I stipulate.
Mr. Brown, is that, would you so stipulate to a delay beyond the 63-day court rule for adjudication?
Given the circumstances, I would.
All right, Mr. Sommerfeld, I assume that you agree with that as well?
I do, and thank you, Judge.
All right, appreciate the assistance with that. How quickly can we get witness and exhibit lists exchanged?
Judge, I can do that within 30 days. I would also like 30 days before trial, any evidentiary issues to be filed with the court. I don't want anything coming up last minute, like happened. We had a trial last week. There were some things that changed on the morning of trial. You got to make adjustments. I would like these things done ahead of time because we have more than enough time right now to sort them things out rather than a week or the morning of a trial.
Mr. Delaney?
I would like, once I receive his witness list, an additional 14 days to file my witness list so I can discuss that with my client. As far as the procedural issues, the only one that we had at the trial on Friday that I was involved with was application of a court rule, and the court gave us adequate time to submit briefs, and then the court, it was an error issue. It issued a ruling, so I didn't see any prejudice there, but I don't know what issues would be prohibited here. In fact, motion in limines are provided for by court rule, even on the day of trial. Some things require notice, so I don't see any procedural issues with the court on those motion hearings.
All right, I'm going to set a status conference approximately 10 days to 2 weeks in advance of the trial. All evidentiary issues are to be motioned and set for hearing at that final pretrial so that we can resolve them well in advance of the trial. That gives you 80 to 90 days to get that briefed and whatever else you need to do for that. Witness and exhibit list will be 30 days submitted by the prosecution, 14 days thereafter for the defense. Mr. Brown, if you wish to have any witnesses or exhibits, you would also be done at the time for the defense. So 44 or 45 days from now would be sufficient. Is there anything else? Jury instructions need to be submitted at the time of the final pretrial, final status conference, and that would be one set of jury instructions either approved by all or specific objections made and alternatives offered so that I'm not shuffling with 3 different sets of full jury instructions. I want the attorneys to do that. And Mr. Delaney and Mr. Sommerfeld worked well in the last case to do 99% of that. So I appreciate that. Is there anything else that needs to be addressed today at the pretrial?
Just for my client, Jeremy, do you have my office telephone number?
I have the number I called you on last time. I believe it's you, maybe your cell number.
No, it's the 1508, last 4 digits, that number.
Yes, sir.
Okay, so just use that number and call if you have a list of witnesses. Since we're by Zoom, Judge, he's not sitting next to me. And or if you have email, leave me that on my office phone, and then we can communicate that way. Sometimes that's more effective. Other than that, I have nothing further, Judge. Thanks.
Your Honor, I do see a Ms. Constantino here from the Sioux Tribe. I don't know if she needs to weigh in or wants to weigh in.
Yep, I anticipate that. Thank you. Ms. Constantino, any issues from the tribe as far as what we've done so far?
No issues, and the tribe would also stipulate to waiving any timelines, especially since the children are with non-respondent mothers at this time.
All right, I appreciate that. And would you please feel free in the future to chime in when you're on these calls with me if there is anything that the tribe wants to let me know. I am well aware of tribal issues. I've been a former tribal judge down with in Mount Pleasant, but I sometimes forget to call people that I don't see regularly, so I apologize for that. But please know that I am interested in hearing what it is that the tribe wants to have happen with these kids. And I'm sure down the road we'll be using you again. So I appreciate the time and effort. So Mr. Sommerfeld, any other issues from your perspective?
Yes, Judge. With the submission of jury instructions, historically, and that this is before you taking the bench, I was the only one who was doing jury instructions. Nobody else would. It's a lot of work, and then there's objections, and it's really, I'm almost like working against myself. I would ask that that the other parties also submitted instructions. That's traditionally how I've done trials, where here's my instructions, here's what I think. I mean, I know they are pretty standard, and but again, it's a matter of all parties submitting instructions rather than just the department.
Well, here's what I'm ordering. I don't want 3 separate lists of jury instructions. It's too cumbersome for me. So I'm making the attorneys do the work for me. And I apologize if that's not what you like to do, but that's the way we're going to do it. So you guys are going to have to get together, and whether one of you types them all out or somebody adds to it or objects to it, you guys need to have a conference all together where you are talking about these things. And then if you can't settle it among yourselves, I only want to see the full set plus something that's suggested in addition to it, or taken away from it. But I'm not going to get these 10 days in advance of trial and then try to juggle 3 jury instructions from each of you, and then try to argue it out on the last day of right before the trial starts. So I need one submitted. However you guys want to work out who does the work on that, that's fine with me. But if you're going to have a trial, we're going to have one set of jury instructions sent to me, and then specific objections if we can't reach an agreement. There shouldn't be more than 1 or 2 or 3 objections on jury instructions anyway. But that's how it's going to go. I'm not going to have an inch and a half of paper from each of you for me to try to put together. That's your job as the attorneys trying the case. Anything else?
Let me just add, Judge, that the department and I have probably tried at least 5 cases, maybe 10. I lose track. Jury trials. I don't think we've had any objections to the instructions. They're standard. We might have tried to tweak the verdict form on Friday, but there are really no issues with the instructions because they're so standardized, with the exception of subtracting some that don't apply, law enforcement, things like that, if they don't testify. So I think we're going to be in good order on that one, Judge.
And again, I agree with you. I don't think it's going to be overly difficult. But if Mr. Summerfield is feeling overwhelmed on occasion, I understand that, and defense counsel may need to participate because I'm only taking a look at one. All right, anything else?
No,
Just to clarify, Judge, how long, when do you want the jury instructions? Was that 10 days also?
Correct. Jury instructions at the final status conference, as well as all evidentiary issues scheduled for hearing at the final evidentiary or final status conference. And so we'll do 90 days to trial, 1 day jury trial. We'll have a status conference 10 days in advance of 10 to 14 days in advance of the trial. Witness and exhibit list will be 30 days from today by the prosecution, 14 days thereafter from the defense and the GAL, and all evidentiary issues noticed for hearing and briefed for the final pretrial 10 days in advance of trial. All right, anything else from the council?
No, Judge, I'm clear now. Thank you.
No, thank you.
All right. I do note that both of the mothers are here. I want to ask briefly for an update on the kids from each of them. So Ms. Robinson, could you tell me how Cadence is doing?
She's doing all right, I guess.
Is there anything that you would ask of the court to assist you?
No, not at this time.
All right. Stay in good contact with the department, and Mr. Summerfield, I'm sure, can advise you of those things. Ms. Warner, how are Waylon and Phoenix doing?
They're struggling terribly bad.
I sympathize, and I apologize, but unfortunately, that's a necessary consequence at this point. Same question to you. Is there anything that we can do to assist you?
Nope.
All right. I'll allow you to contact counsel if you wish to as well. And if you don't get notices from the court as to the next upcoming court dates in the next week or two, please contact the court. And so we want to make sure that you get proper notice of all of that as well. All right, that's all for today then. Thank you all very much.
Is there any
I'll
way
see
I
you.
can get my mail
Go
to a
ahead.
different address?
Well, you can certainly change your address, your mailing
Okay.
address if you'd like.
Because I don't feel comfortable going to my my mailbox right now because Cadence is trying to say some things that did not happen, and I'm not comfortable with going up there.
All right. What I'm gonna do then is ask you to submit something in writing to the court so that we have that from you as to your new mailing address that you want to use. So if you'd send that to the court, we will then use that as your new mailing address and send all of our notices to that new address that you want to use. Is that all right, Ms. Warner?
Yep.
All right. We'll do things that way then. Thank you very much. That's all for today. We'll be in recess.